Hello, my name is Jon Macklem. I'm a partner at the law firm of Christian Small in Birmingham, Alabama. I'm also part of the firm's labor and employment practice group. Today I want to talk very briefly with you about employee handbooks and why now is an important time for all companies, regardless whether you're small, medium, or large, to analyze and evaluate revisions that you may need for your employee handbooks. What's necessitating or prompting this need? Well, the first is the Me Too movement. As you all have kept up with and are aware of, the Me Too movement through a series of high-profile cases has brought to light cultural issues and employment issues regarding gender harassment. The Me Too movement has certainly brought to light the need for companies to evaluate their policies and procedures. While the EEOC has not seen an uptick in claim activity, certainly traffic to the EEOC through their website as well as communications from claims has increased significantly over the last year. And very recently, the federal government has approved a $16 million increase in part to address some of these issues. We at our firm are finding increased traffic where employers have come to us not only to create strategies for improving culture at their offices, but also to evaluate policies and procedures and reporting harassment. It benefits the employee and the employer by having a policy that is widely known, appropriately disseminated, to make sure that the right people are being notified about the harassment. From the employer perspective, that can serve as the most powerful defense if litigation or claims arise to protect a company by having an effective employment policy. These policies that you can get for free online are often very vague and nondescript, and it's important for each individual company to evaluate what is an appropriate and what would be an effective reporting mechanism if any employees had any harassment or discrimination claims that they feel that they need to bring to the attention of the company. The second aspect of why it's an important time to evaluate a company's employment handbook is the Supreme Court's decision recently in late May, where in a series of cases, Epic Systems or Murphy Oil, a series of cases were all consolidated, and the U.S. Supreme Court decided in a very closely, hotly contested decision that arbitration waiver provisions in employment agreements do not run afoul to the National Labor Relations Act. This is very important for employers to consider whether including such types of provisions in their employee handbooks is important to limit exposure or to determine if arbitration is more appropriate. Whether arbitration is or should be utilized by a company is a judgment call where a company has to weigh a lot of different factors. In some instances, arbitration in an employment setting is not the best solution for an employer. But nevertheless, in light of the U.S. Supreme Court's recent decision, companies should take that decision in an effort in getting with their legal counsel to determine whether those changes should be made in conjunction with also evaluating reporting policies for any harassment. And so I hope that companies out there will utilize these two developments, these two movements, if you will, to evaluate their policies and procedures. Of course, if you have any questions or would like to discuss, feel free to contact me or any of our other members of our labor and employment practice group. Hope you have a great day.